The college students accused of luring a man to campus, falsely accusing him of being a pedophile, only for all this to end with him allegedly being chased down and attacked, they are fighting to have the charges thrown out. Do they have a strong argument? I'll tell you what, there could be a lot riding on this case as we are seeing more and more disturbing trends on social media of people engaging in amateur predator-catcher stings, and that is a real problem. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, so we have a follow-up to a story that we did previously where you have these students from Assumption University out in Massachusetts who were charged criminally in an alleged to catch a predator style amateur sting operation. This is wild. The allegation being that they wrongfully targeted a suspected pedophile, leading to a group of 25, maybe even 30 people reportedly chasing this man, assaulting him, with his head even reportedly being slammed into a car door before he could drive away. And this all reportedly happened on October 1st of last year. And apparently this was caught on tape. Someone was reportedly filming this interaction. But now what is happening? You are having the defendants moving to have the charges dismissed. The Assumption students that we're talking about, Easton Randall, 19 years old, Kevin Carroll, Isabella Trudeau, Kelsey Brainerd, Joaquin Smith, all 18. They have all been hit with kidnapping and conspiracy charges. These are very serious felony charges. Brainerd actually faces an additional charge of intimidation related to allegedly misleading authorities, and Carroll faces an additional charge of assault and battery with a dangerous weapon. But now you're having all 5 students. They've filed paperwork to try to have their charges dismissed. The question is, could they get the case thrown out? Is the judge entertaining it? Before we even get into all that, I got to lay out a little bit more of the narrative here so you know what we're talking about. So they are accused of working in tandem with another unnamed person, a minor who's also been charged, to lure the victim, a 22-year-old active duty member of the military, to the campus before falsely accusing him of trying to meet up with a minor, riling up a mob to chase him, and then allegedly attacking him. And I say falsely accused because according to reporting, like from Telegram and Gazette, police looked into this, and apparently there was no evidence to indicate this man was looking to have sexual relations with a minor. Rather, he apparently had been communicating with Brainerd on the dating app Tinder, and her profile listed her as being 18 years old. By the way, in Massachusetts, the age of consent is 16. Now, actually, according to Officer Christopher Shea's statement of facts in support of an application for a criminal complaint, which we're going to get to a lot, now, the alleged victim from North Carolina was in Massachusetts, was actually in Worcester to attend his grandmother's funeral, and wanted to be around people, so he started communicating with Brainerd on Tinder. And the plan was to meet up and hook up, and she allegedly requested that he, quote, meet her at Alumni Hall next to the Kennedy building. And he claims that she let him into the building, and then in minutes, a group of people come out, started calling him a pedophile. He claims he was surrounded, grabbed, held back from leaving, but was able to run away and started getting chased by that group of 25 or more people. And he claims he gets to his car, he's punched in the back of the head, the car door slammed on him, his car gets kicked, drives away, calls police. Now, apparently, police collected the surveillance footage. And according to this statement from Officer Shea, it seemingly matches the alleged victim's description of events. But it also includes footage of this group with cell phones out, seemingly recording the episode, them laughing, high-fiving. Brainerd is allegedly a part of this group. And interestingly, the officer even says that this looks staged, or that they were all waiting the alleged victim to arrive. And the officer adds that Brainerd's account to police was false, namely where she said that there was a, quote, creepy guy who came onto campus, quote, unsolicited and was, quote, uninvited, and that he was a sexual predator. And when it comes to Miss Brainerd, the officer writes that when she was confronted about these inconsistencies in her account, she essentially caved, but said she didn't know what was going to happen, that she wasn't part of the incident, and that she allegedly put the blame on Randall. Hey everybody, this is a Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to all this? Yeah, well, Morgan & Morgan is stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. Now, before I get into these motions to dismiss, I want to bring on Massachusetts criminal defense attorney William Korman to talk more about this. William, thanks so much for taking the time. Really appreciate it. You're Your book collection rivals mine, so that's intimidating to say the least. But what do you think about all this? Because this is not the first time that we're seeing this like spur of amateur predator stings, particularly online.
I think it's a dangerous case. I think that these types of online vigilantes are dangerous. I think that this could have gone in so many different directions. I think that these kids were swept up in this sort of online fever, if you will, to try to gain some notoriety online. And I think it could have gone 100 different ways. This outcome is probably the best and safest outcome for all concerned.
Let me amplify that a little bit. So according to the Telegram and Gazette, the New York Times reported that since 2023, there have been more than 170 of these kind of violent amateur attacks by so-called predator hunters, mostly due to this fad online. And actually, in Officer Shea's statement, he claims that the goal of this event was to simulate what's being seen on TikTok of this predator catcher viral videos. Chris Hansen's a friend of mine, so I know what the real deal is here, William. When he implants himself with law enforcement before these stings, talk to us about, obviously, there's a danger aspect, right? Even if you're catching a suspected pedophile. You know, imagine what the result could be. You think that person could be a danger to everybody there. But even putting that aside, why is it so important, aside from a safety point of view, but from a legal point of view? Let's say you think you're doing good and you're trying to catch criminals. Why is that problematic doing it this way in terms of, an actual prosecution and evidence that might come in? Because I think this could taint a potential case.
Oh, sure. And we see that happen all the time. I mean, first of all, they don't know who this guy is. This guy could have had a weapon. This guy could have turned around, and if he had a firearm and he was being chased by these folks, this could have been a disaster. From a prosecutorial standpoint, like you said, when Chris Hansen does these things, it's professionally done, it's thought out, there are fail-safes in place, there are circuit breakers in place, and it's not just done off, from the seat of someone's pants. Those cases themselves that Chris Hansen is involved in, those are difficult to prosecute as well. But in a situation like this, if the goal is online notoriety, this is the dangerous side of it, right? You have dozens of people running around with cell phones, chasing some guy who doesn't know what's going on. It's a setup, it's foolish, and it's scary.
Let's get into some of the arguments here. So first, let me go to Kevin Carroll's paperwork, this motion to dismiss, talking about why the kidnapping charge should be dismissed. Because if you focus on the essential element of, quote, forcible or secret confinement or imprisonment, and if you look at the video, the alleged victim was never restrained in any way by the defendants, that to state otherwise is an unfair and misleading presentation of what happened. In terms of the conspiracy charge, the argument is there was insufficient probable cause in Officer Christopher Shea's application for the criminal complaint that Carroll formed a, quote, unlawful agreement to kidnap the alleged victim here. The idea being that it's alleged that Randall was with, quote, the charged defendants when the idea of catching a predator was discussed, the goal resulting from the conversation and text messages with others to be either physically assaulting or calling the police on the target. While the applicant may make a summary allegation that this evidence amounts to a conspiracy to commit a kidnapping, that is not the legal standard at a motion to dismiss, which exists to serve as an effective protection against unfounded criminal prosecutions. The defendant hereby incorporates the factual arguments of co-counsel regarding the lack of admissions in Mr. Randall's recorded statement and states that this raises both McCarthy sufficiency issues as well as Odell impropriety issues. Now, William, I imagine those are key cases in your jurisdiction, but talk to us about what you make of this argument for why the kidnapping and conspiracy charges should be thrown out.
So I'm a huge fan of creative legal arguments, and this certainly is one. Massachusetts for kidnapping does require some sort of prohibition on movement, and the cases have interpreted that relatively broadly. And in this particular case, I think the key question is when does the kidnapping occur? And from what I've seen, it's a little murky. It's not bringing the gentleman into Alumni Hall. It's not chasing him. And they do allow him to get into his car. I suppose the issue is when 24 college students surround this gentleman's car and hit the car and kick the car. At that point, are they preventing him from leaving the scene? If they're preventing him from leaving the scene at that stage of the game, then I do think that it does meet the factual requirements for a kidnapping. But until that moment in time, he was able to leave. I've seen the video. You've seen the video. He's surrounded. He's able to leave. He runs up the stairs. He runs outside. But I think it's the surrounding of the car that becomes problematic. And I think that a judge looking at the case broadly will say, it's not the strongest kidnapping case out there, but it does meet the elements in that particular set of facts and circumstances. The conspiracy is a little more challenging because I do think that there may be some validity to the argument that they didn't plead the conspiracy charges correctly. Usually in the Commonwealth of Massachusetts, there's a requirement that there be specificity about what the conspiracy was to do. In other words, what was this group conspiring with one another to actually accomplish? It can't just be conspiracy in a vacuum. It has to be conspiracy to do something. And my understanding is that that's still a little vague in the pleading documents, and that may be a problem for the prosecution.
Can they amend it? Can the prosecution amend it?
What the prosecution can do is dismiss it and recharge.
Interesting. Okay, so let me add a little bit more to Mr. Carroll's argument. So it says, quote, the defendant additionally states that Exhibit 1 fails to establish anyone had the shared plan to commit a kidnapping, let alone form an agreement amongst them to do so. Furthermore, just because this defendant, Mr. Carroll, was allegedly in a place at the time of text and verbal communications by Mr. Randall does not establish probable cause, as it offers no insight into Mr. Carroll's state of mind. This is because intent is a requisite mental state for conspiracy, not mere knowledge or acquiescence. At best, the statement of facts describe a group of people who gathered to confront the AV, the alleged victim, who they believed was engaging in morally objectionable behavior. Nothing in the narrative indicates Mr. Carroll was on the text chain or contributed to the conversation. Nothing in the narrative indicates Mr. Carroll was in the lounge area when the AV was confronted or directed the behavior of people while there. Any interactions between Mr. Carroll and the AV took place in the parking lot. Mr. Carroll is alleged to have shut the AV's car door and struck the AV's head in the process. Nothing in the statement of fact claims Mr. Carroll prevented the car from moving or restrained the AV on the way to the car. What follows is that the applicant decided what he wanted to charge this group with, regardless of what the evidence actually was. So, William, the argument is, you talk about a lack of specificity, that you might have individuals engaging in wrongdoing, but you can't just group them all together, right? He may be facing legitimate assault and battery charges or something of that nature, but you can't say he might be a part of the conspiracy, right? It becomes very fact specific. What do you make of that argument, that essentially the officer was just grouping everybody together?
I think it's a strong argument for the defense. I think it's a very strong argument, as a matter of fact. There's no evidence of this particular individual, that this particular defendant knew of the plan ahead of time, participated in the plan. He was certainly swept up in everything. It appears as if he did commit a crime. He did commit a felony, assault and battery with a dangerous weapon, by hitting the gentleman with the car door. But to charge him with the conspiracy, I think it was prosecutorial overreach, and I think the judge will dismiss that charge.
So when it comes to Easton Randall and Joaquin Smith, both of their motions to dismiss argue there's insufficient evidence to amount to probable cause under the Massachusetts Rules of Criminal Procedure. Kelsey Brainerd makes a similar argument that the evidence presented is insufficient to establish the necessary elements of the offense. But William, what I really want to show you, want to read a part of, is what was in Officer Shea's statement, this one that I keep referring to. And let me read it out. Quote, Easton Randall reported that the whole incident started out on Tinder with messages. He reported that it was like the Chris Hansen videos where you catch a predator and either call police or kick their ass. Mr. Randall reported that the catch a predator is a big thing on TikTok currently, but this got out of hand and went bad. Mr. Randall reported that they all made suggestions and agreed to what information was texted. Mr. Randall was asked about the alumni third floor group chat and acknowledges its existence and reported that he used it to text some guys stating, like, you have to come down here, we're catching a predator. Mr. Randall reports that Smitty was texting with some guy and put underage in his text, and a mass of people came down after that. Now, William, is it tough for him to say that there's insufficient evidence at this point to establish probable cause when you see what he allegedly admitted? Or, again, are we dealing with a situation, one person saying one thing, one person saying other thing? It was a series of bad decisions, but nobody was on the same page about what was going on.
I think, well, it certainly was a series of bad decisions. Who are we kidding?
Sure. Yes.
As far as from a defense standpoint, what I would say is this: there did not seem to be a common agreement to do a particular act. I think there was an agreement for a whole bunch of kids to arrive. I think there was an agreement to confront this gentleman. And as the young man said, things certainly did get out of hand. But if the agreement itself was just to confront this guy at Alumni Hall, that does not a crime make. Again, terrible judgment, terrible idea. It could have gone horribly, horribly wrong in so many different ways. But I don't know that that's a conspiracy in and of itself. Because there needs to be an end game. A conspiracy to do what? And it's the what that seems to be missing here. It's the what that needs to be criminal.
And you're saying a conspiracy to confront him, right, wouldn't be enough? Because it seems like there was a plan to lure him there, or allegedly lure him there. And I guess it's a question of what the plan was to do next, right? I mean,
correct.
Did it have to be, oh, we want to lure him here in effort to hold him? We want to have an effort here to beat him up? I mean, I don't know. You tell me what you think you're going to hear as a response from prosecutors, and then I'll get to Isabelle Trudeau's motion.
Well, I think you hit the nail right on the head. If there was a conspiracy to lure him here and hold him, that's a kidnapping. If it was a conspiracy to lure him here and beat him up, that's a conspiracy to beat the guy up. If it's a conspiracy to lure him here, we're missing the next step. And there's no proof that I've seen, certainly not in the officer's statement of facts. There's no next step here. And again, terrible planning, terrible judgment, terrible idea. But from a pure legal argument, I think that the defense counsel prevails. I think they win. I don't know what the prosecution is going to say, because I think that they're missing that key element of bringing them there and conspiring to commit a criminal act. What is the criminal act here?
I'll get a little bit more to the prosecution in a minute, maybe a potential response, because I want to relay what happened in court. But you go to Isabelle Trudeau's motion to dismiss, and it says the following, quote, Officer Christopher Shea of the Assumption Police Department writes in his application for complaint statement of facts that upon interviewing Mr. Randall, who was one of the 6 individuals charged, reported that the whole incident started out on Tinder with messages being sent back and forth between Miss Brainerd and the complaining witness. Additionally, Officer Shea writes that Mr. Randall was sitting with Kelsey, Bella, Smitty, Kevin, Ben, and a juvenile, and they all made suggestions and agreed to what information was texted. Officer Shea, labeling these 6 individuals as the core group or primary group, further writes the group continued to contact the complaining witness and conspired with each other to deceitfully lure and rallied other students to assist in confining the complaining witness. Ms. Trudeau is not mentioned in the statement until page 5, and the only so-called fact inculpating her is from Mr. Randall, who was also charged. There are no specific facts within the statement that rise to a level to find probable cause to issue a complaint against Ms. Trudeau. There is no corroboration within the statement of the Assumption Police as to anything specific Ms. Trudeau is charged with. Now, William, it seems to me that that argument is, very consistent with what we've heard before. You're grouping me into everything else, but also you're relying on one of my co-defendants to support the charge here, and that's insufficient. What do you make of that?
Well, I think I think that can happen. Obviously, if one conspirator turns on another and ropes them in, or tells the police officer that, it wasn't just me, it was also Jim, that's valid. But I also think that's a good argument there. I mean, the fact of the matter is that there were a lot of kids on the scene here. And I think that the officers cast a very, very, very wide net. They almost took a shotgun blast approach. We're going to grab every kid who we know and we're going to charge them. And her lawyer is absolutely correct. I don't think there's anything that she did. She was there, being present on the scene, and isn't in and of itself a crime. It doesn't sound as if she struck the alleged victim. It doesn't sound like she chased the alleged victim. It doesn't sound like she tried to kidnap or confine him from going anywhere. It just seems that she knew about it and consequently got dragged in.
Well, now I want to go to what happened in court, and if there's anything we can glean from what happened in court last week on this. This is according to reporting from Telegram and Gazette and Mass Live. So defense lawyers made the argument that what law enforcement, what authorities are doing here, what prosecutors are doing, are misrepresenting who did what and what happened, that there wasn't sufficient evidence of kidnapping. Trudeau's attorney, Robert Icovelli, reportedly argued that Shea's statement wasn't sufficient to support the charges, that it relied on the accounts of questionable witnesses. Leonardo Anguilo, attorney for Carroll, reportedly told the court, "You've got a bunch of kids making bad decisions," but emphasized that this does not rise to the level of the charges that they now face. And Anguilla also added that you have defendants here who believed that this alleged victim was engaging in bad conduct, morally questionable behavior, and added, quote, they decided they wanted to confront a person they disagreed with. Isn't that what college is all about? Now, the judge overseeing the case, Michael Allard Mattis, reportedly responded, that may have been a bridge too far. Assistant District Attorney Alexander Malone argued to the court that the charges should stand, really focusing in on a video, which apparently was played in court and again reportedly filmed by a student, to show this was a planned event, that there was evidence of confining or restricting for purposes of kidnapping. And Judge Allard Mattis remarked at the end, you've given me a lot to think about. So he's going to reserve the decision for a later time. What do you think the judge is going to do here?
I think the kidnapping charge is going to be very, very fact specific, and I think the judge may have an opportunity to review that video over and over and over again. If there is an effort to confine the alleged victim, if there is an effort to surround his car, to prevent that gentleman from leaving the scene, then I think the elements are met for kidnapping. If that doesn't happen, if the video doesn't show that out, and there's no mention within the text thread of what exactly they're going to do, I think the conspiracy charge falls by the wayside, and I think the kidnapping charge falls by the wayside. Again, the conspiracy seems to be to lure this gentleman to campus. That's not a crime. Again, terrible idea. Poor decision-making all around, but nevertheless, that's not a crime in and of itself.
Now, Judge Allard Mattis has scheduled the next date in the case for May 19th. But, William, one other thing I wanted to ask you before we wrap up is they're facing very serious charges here, right? Kidnapping, conspiracy. Kidnapping could be 10 years in prison alone, right? And I'm wondering whether or not, all said and done, prosecution looking at potential weaknesses in this case. Obviously, the defense will wait to see what happens with these motions to dismiss. But if they're not dismissed, do you think that there's a plea deal in the works? Do you think that that could be on the table, and what would that look like?
So I think obviously there's a lot of defendants here, and I think different defendants have different levels of culpability. So if the case isn't dismissed, the young lady who initiated the Tinder conversations and participated fully, I think she's got a significant amount of jeopardy here. I really do. 98% of all criminal cases resolve themselves short of trial. So I think that from the get-go, it's almost safe to assume that most cases resolve themselves with a plea bargain. But again, we have a lot of kids here facing a lot of different charges. I think the motion to dismiss is important. My understanding is the lawyers weren't looking to dismiss the assault and battery charges, so some of those charges are going to stick regardless of what happens as a result of the motion to dismiss. I think that the lawyers didn't ask to have the intimidation or falsification charges dismissed, and so those charges are going to stick. Again, these are some young folks who have made a terrible decision, and I really do think that the prosecution of them at this level is probably the best outcome, because this could have gone horribly wrong in so many different ways for everybody.
Now, let me just end on this. Assumption University had released a statement calling this conduct, quote, abhorrent and antithetical to Assumption University's mission and values. While we cannot comment on the ongoing student conduct investigations and attendant disciplinary processes, Assumption University is committed to maintaining a campus environment where every individual is treated with respect and dignity, including guests. We strongly condemn all forms of violence and misconduct, and we are dedicated to fostering a community where all individuals feel safe and supported. William Korman, thanks so much for taking the time. It was great talking to you.
My pleasure. Thank you very much.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.